So I'm Christine Fillmore. I am an attorney at the law firm of Drummond Woodson in Manchester. Matt Surge, my colleague, was supposed to be joining me today, but unfortunately he is not able to be here. So I am going to limp through this by myself. We'll see how that goes, and I'll try to speak a little quickly, being mindful of your time. Questions. I'm going to try to address questions as we go. Please write them in the chat. I'll get to as many as I can, and I'm also going to try to leave time at the end to answer questions as well. Oh, and also my email address will be on the last slide. So if I don't get to your question, or if you think of something afterward, please feel free to send me an email. Just be sure to tell me that you were an attendee at this session so I have some context. And with questions, general questions are better. If you have a very specific question about a particular application or situation, that might be something better for me to answer later after this session. And also, before we start, I want to echo what Chris Bolt said about reply all. Please don't. Ever, ever, ever. Email is not your friend under the right to know law. So if there were no reply all button, the world would be an easier place for us to handle. So I am going to be talking about ZBA decision making, and that involves a lot more than just the deliberation at the end of an application and the decision that you make. Everything that happens before that feeds into the decision, and the validity of whatever decision you make is going to be highly dependent on following all of the required steps and making sure that everybody's rights are respected. And the success of your town attorney in defending your decision, if necessary, in front of the Superior Court or the Housing Appeals Board is going to be highly dependent on the record that you create as you go through this process. So I'm going to point out a bunch of places where that can go wrong and how you can avoid that. I'm going to start out at first with a few basic concepts that underline everything else that I'm going to talk about and will make them make a little more sense. And so any of you who have heard me speak before, some of this is going to be familiar, but I think it bears repeating. So you are a part of a zoning board of adjustment, and the zoning board exists as a safety valve to prevent land use regulation from essentially taking private property. And that would be in violation of the federal and New Hampshire Constitution. So land use, if you think about it, is a balance between what people can do with their property and the need for society to regulate what people do with their property. And so zoning ordinances and all of your regulations necessarily put some limits on what people can do with their private property. And the zoning board exists, for the most part, to look at situations where that regulation is too extreme. And so when you are, for example, granting a variance or looking at it, your job would be to bend the rules just enough to prevent the zoning ordinance or regulations from taking somebody's private property rights in a way that's not fair. And as a member of a ZBA, what your board is doing is essentially like a judge. It's referred to as quasi-judicial. So you're not actually judges, but what you're doing is essentially like what every judge does. So you're not legislative. You don't create or amend your zoning ordinance or the site plan regulations. You're not an executive body. You don't carry out the ordinance. You are not the enforcement body. So you make decisions, but you're not the one who will end up enforcing them. What you do is quasi-judicial. You interpret your ordinance and the regulations, and you apply that interpretation to whatever the application is and the facts that you find out. And every time you act as a board, somebody's property is at stake. So that means that all of the procedural concerns get elevated. And I'm going to talk about what the procedures are that you need to be worried about as we go along. If you remember nothing else from what I say, these three things are really important. Read and follow the statutory requirements. If there is a statute that says that notice has to be provided within so many days before a hearing, you have to do that. It's not a suggestion. you have to do it. Read and follow your own ordinance and rules. So if you have rules of procedure, for the most part, try to follow them. And always be fair and reasonable. If it feels like you're not being fair, then you may be doing something a little bit off. And we add a fourth one to this slide, which is get legal advice if you think that you need it. Do not be rushed into making a bad decision because you're not sure what you're supposed to do. If there's any question at all, stop what you're doing, get legal advice, and then go back and finish. This one's really important. The fundamental rule of municipal government in New Hampshire is that municipalities get all of their authority to act from the legislature. That means that you have to find a statute that authorizes whatever action it is you want to take, or necessarily implies that action. So if you're allowed to get legal advice, it necessarily implies that you're allowed to pay the lawyer for that legal advice, for instance. And this is very different from virtually every other organization in New Hampshire, every private business, every individual person. What we normally hear is, well, there's no law that says I can't do it. But municipalities can't say that. We have to go one step farther than everybody else and find a law that says that we can. And then we have to make sure that the way that action is being taken doesn't conflict with whatever that statute is. This also means that a municipality or a board like the ZBA cannot have an ordinance or a rule or a procedure that's not authorized or necessarily implied by a statute, or that is in conflict with a statute. So if your rule of procedure says that you don't have to give 5 days notice, you only have to give 4, that would be invalid. It's a pretty basic one. So when you're thinking about standards for variances, things like that, that are the what of what you do, and then your procedures, which are the how of what you do, it can be helpful to remember that you can only do those things in a way that the legislature says that you can. Also, relating back to the constitutional issues, you probably have heard the phrase due process. Essentially what that means is that people have a right to know what's going to happen that might affect their property or any other right that they have, constitutional right, to know about it ahead of time and have some kind of opportunity to participate meaningfully before a decision is made. And as part of that, that means that citizens, property owners usually, have the right to know how stuff works. So what that means for you is that municipalities and all of your boards have a constitutional obligation to provide reasonable assistance to all citizens with the process. And that means reasonable. So examples of what that means would be making your ordinances, your regulations, your forms, your instructions easily available to all citizens. It's very easy if you just put them on your website. Everybody can get them from anywhere. When people are asked in your office, how do I apply for a variance? You have to tell them. You have to make it easy for people to understand what it is they need to do. Where's the form and how much does it cost and who do they make the check out to? And is there a deadline by which they have to get it in so that it can get on the agenda for this next meeting? All of that stuff. Having said that, the line that municipalities should not cross is giving legal advice. So while someone can come in and say, how do I apply for a variance? And they need to be told how that happens. If they come in and ask, will this thing I want to do qualify for a variance? Don't answer that question. What you can do is direct them to the ordinance and the regulations and the law, if you know it, and then tell them, I can't tell you if it will qualify. You probably should look at these things and talk to your own lawyer. And I am just checking on the chat to see if there are questions. Okay. I'm going to keep going with these for a minute. So as I said, the ZBA is a quasi-judicial board. So what that means is you collect evidence and you hear testimony. This is all at your hearings and the documents and records that people submit to you and the application, all of that. From all of that, you find some facts. You also can use your personal knowledge. Obviously, you all live in the community where you are a ZBA member, so you probably are familiar with the area. You might know something about that particular piece of property, the traffic, all of that stuff. You can use all that knowledge. And then you make your decision based on the facts as you have found them, and you apply legal tests to reach a decision. And you can approve or deny or modify the decision that's being appealed to you. You can impose reasonable conditions that are related to whatever the issues are you're looking at. In every case, when an applicant comes to you, whether they're appealing the denial of a building permit, or they're asking for a variance, or looking for a special exception, it is always on the applicant. The burden is always on them to prove to you that they qualify for it. It is not the burden on the abutters to show that they don't. And in the course of doing all of this, you are going to develop a record for possible court review. I think it's important to note that just as when a judge is reviewing a case, if it is high profile, if there's an application or an appeal that's very high profile, that it's controversial, a lot of people are paying attention, that is a time when you might want to be extra careful, to be fair with the process, a little extra fair, and to really consistently apply the facts to the legal tests to reach a decision, because you know people are looking at it. But having said that, that's something that a board should be doing every single time. And the more consistently that you do it, the easier it is to do when you have a high profile case that everybody's paying attention to. And on the flip side of that, just because nobody objects to an application, that doesn't mean that it should get approved. The standard is exactly the same every single time. And as I said, don't be rushed into making a mistake. Get legal advice if you think that you need it. All right, so a little bit more about process here. The Constitution, the US Constitution and the New Hampshire Constitution require that everybody gets due process, procedural due process. So the basic outlines of that are notice to people who are affected, that's usually the applicant and the property owning abutters, of what's being proposed, an opportunity for all those people to be heard at a public hearing by you, the ability to appear and speak before you, either themselves or through counsel or some other representative. They have a right to have a decision made by an impartial tribunal, that's you, a deliberation that you do based on the evidence and the facts, and then to get a written decision of what your decision is, and then the opportunity to appeal to seek correction of errors that they think might have occurred. And so in New Hampshire, all of those things are required by the specific statutes on this slide. And that's where all of these requirements come from. And the reason that I'm going over all this is that even if you make a substantively perfect decision, your decision is correct. You apply the facts to the law and the ordinance and all of that. You do all of that. If someone appeals your decision and the court or the Housing Appeals Board finds that you have messed up the process along the way somewhere and that any party's procedural due process rights were violated, they didn't get their notice on time, they weren't allowed to speak, anything like that. If that happens, the court can invalidate your decision, overturn it, send the matter back to you, and you have to start all over again, which is an enormous waste of time and effort and money, frankly, because now you've had to pay somebody like me to go into court and try to say, no, judge, it was fine. But it gets sent back to you anyway, and now you have to start again. So I think it's really important to pay attention to the process as you go. In the course of dealing with applications, there are frequently times when an applicant requires approval from the planning board for something and from the ZBA. They may need to get site plan approval and a variance, and they know going into it they need a variance. And when that happens, there's often a question of which board do they go to first, whose conditions are going to control. So say they go to the ZBA first and get their variance, and then they go to the planning board, but the ZBA has put conditions on the approval. The question about where you go first is there's no one right answer to that. Towns and cities do that differently. So I think the best thing that I can say is that this is something that it's frequently good if it's in the zoning ordinance. If someone needs a variance, or if they need relief from the ZBA, they have to do that first and then go to the planning board. There are some places where applicants are allowed to go both places at the same time. They can apply to both at once. Developers frequently like that because they can have both processes working at the same time and it saves them some time. And any way that works for you is fine. And joint meetings, if they are allowed to go both places at the same time, sometimes it can be really efficient for the planning board and the zoning board to hold a joint meeting, a joint hearing. If they're going to be hearing the same sorts of things, they're going to get essentially the same presentation, although there's going to be some focus on, say, the 5 variance criteria and the specific site plan regulations. But the basic presentation is going to be the same. So you might want to have a joint hearing. And when that happens, usually the planning board chair is in charge of the hearing. But very important is that each board has to have their own minutes. They have to provide their own notice. And then when it comes time to make a decision, each board has to make their own decision. They should deliberate separately according to the criteria or ordinance factors that apply to whatever decision they're making. So as long as it makes sense and works in your community, that's fine. And then finally, on the preliminary procedural stuff, one bite at the apple. So usually an applicant can't apply for the same thing over and over and over again after it's been denied. They get one shot. They come in, they ask for a variance for this project, they don't get it. Can they come back over and over again and waste your time and everybody's time? And the answer is no, for the most part, unless something has changed. The second application has to be materially different from the first one, and that can happen in 2 different ways. One is if the legal standard has changed. So about 10, 12 years ago, there was a change in the statutory standard for variances. The 5 variance criteria were revised. And after that, there was a case where the court said, the standard has changed, so it's possible that you get a different result now on the same facts. So you're allowed to apply again. The same thing could happen if your ordinance changes. The same project might qualify now when it didn't before. The other way is if the application itself changes in some way that is meaningful. Usually that means it's changed in a way to address the reasons it was denied in the first place. It might not be good enough to get accepted the second time, to be approved the second time, but it has to be changed in some way that means the answer might be different this time. Okay, I'm going to take a peek at the chat here just to see if there are questions that I probably should answer. Okay, most of these are about correspondence between, okay. The one about an application says they want you to, applicant says they want to continue the hearing so they can appear in person. Are you obligated to continue the hearing? Probably not, although I would suggest that you might want to. Everybody has an opportunity to be at the hearing. If it's the applicant, I would say the first time, give them the benefit of the doubt, continue it and let them be there, because that will be easier for somebody like me to defend to a judge. If they're just trying to delay it, maybe not. But it might be dependent on the specific facts, so you might want to talk with your town attorney. Emails. Oh, to refine that question, the organization in question is a neighboring town wanting to speak on regional impact. Okay. As I don't know if Chris Bolt covered this, but if there is somebody from a neighboring town who wants to say, we think this will have regional impact and you should find regional impact, then you don't necessarily have to continue it in that case. But again, when in doubt, if you can do it reasonably, it's a lot easier if you just do it. And conditions, I'm going to get to that in a minute. Okay. If an applicant withdraws an application before there is a ruling, then reapplies with the same, essentially the same application, does the one bite rule still apply? It does not. That only applies to an application that you heard all the way through, you made a decision, the decision was final. If it stops short of you making a decision, then it's Fisher versus Dover doesn't cover it. It's not considered a second application. Okay, now I'm going to get into more of the specific steps that lead you to a well-reasoned, well-founded decision. Right from the start, you can help applicants provide you with all of the information that you will need to get. And you can start with that right from the beginning with your application form. It can give you a roadmap, and it can give the applicant a roadmap for what it is you need to know. And those things are going to be different depending on what they're applying for. So with a variance application, obviously, you want to tell them what the standards are. These are the 5 criteria. You must satisfy all 5. Here's what we want to know. With a special exception, that is going to be really dependent on your ordinance. Your ordinance should spell out exactly what the conditions are that every applicant needs to meet for a special exception. And they may be different for different kinds of projects. There might be the general special exception conditions and then maybe 2 or 3 extras for a particular kind of use. And there's really not any specific requirement for what you put in your application, but generally speaking, it's a good idea to ask for the kinds of facts you need to know. If they don't fill in that part on the application, you know what to ask them about. You obviously want a description of the proposal and why it should be granted. Why does it meet all of the factors or elements? I think it's also a good idea, based on things that I have seen over the years, to try to provide information, maybe in a separate instruction sheet, in language that everybody can understand. The first time I read the 5 variance factors, I didn't know what they meant either. And I'm a lawyer. So the average person who is not familiar with variance law probably has no idea what substantial justice would be done actually means. Now, there are a lot of sources for how you can explain that. And as I said, you don't want to be giving them legal advice. But there are some very general explanations that are available from OPD in their handbooks. Your town attorney might be able to help you write some instructions that are more user-friendly, that say, for example, here's an example of this, or in plain language, here's what this means generally, so that there's somewhat of a better shot that the applicant is actually going to be giving you the information that you need. And then, of course, you can try to refine that with them during the hearing. And I will say that if they don't give you all of the information, and frequently they won't, no matter how specific you are on your application form, if the applicants are not giving you the information that you need at the hearing, you can walk them right through it and say, all right, we have not heard from you about substantial justice. Can you talk to us about that? Why does this application meet that? And try to draw it out of them a little bit. And if they still don't give you anything, then you've got a pretty good case for saying, I don't think it's qualifying. There is a question about if an applicant, can the rules of procedure deny the applicant the right to withdraw if a public hearing has already started? That's a good question. No, you can't do that. And that is because that's within the applicant's control. They can't be forced to finish an application. They can abandon it at any time. And I have seen that frequently where an applicant realizes that they are going to be denied. It is definitely not going to be approved. And so they withdraw it, revise it a little bit to try and do a better job, and they come back. And that time, the second time, they do a better job, maybe. But that is something that is up to them, and they can do that at any time. The hearing, so getting back to the procedures, The applicant has the right to have the board act promptly on the application. So the law requires that you hold a hearing within 45 days of the receipt of the application. Now, it's possible that you're not going to meet the 45 days, particularly if the applicant can't get you all of the information in time, or you schedule it and they say, I can't be there that night, or my engineer can't be there, or my lawyer can't be there. Can we do it a different time? If the applicant asks to continue it, then you're off the 45-day hook. And also, this is just that you have to open the hearing within 45 days. It's not that you have to decide the application. The planning board has a time limit within which they are supposed to decide an application, but there are federal laws that might place a time limit on you. And the biggest example is telecom facilities. So if somebody wants to put up a cell tower, there's a federal law that says the whole town approval process has to be completed within a certain number of days, depending on the kind of facility that it is. So specifically with telecom facilities, if you get that application, you should be checking on what it's called the shot clock, what that is. Notice of the hearing, certified or verified mail has to be sent out to all parties, applicant, abutters, at least 5 days before the hearing, and newspaper publication. As I said before, you can't provide less. So your rules can't say 4 days or 3 days. Your rules can't say send it by regular mail, not by verified mail, because the law requires a certain amount. And the general rule is you can always provide people with more notice, but not less. So if your rule says 10 days instead of 5 days, that's more work for you, but that's fine. The law it complies with the law. And so when you have a question about that, always apply the longest time period, the most notice, the most different kinds of notice, posting, publish, sending it. Whatever applies, your rules or the statute, do whatever is the most, and you will probably not go wrong. This is a really good question. Does any applicant or abutter have the right to have a full board of 5 members or alternates who are designated hear and decide their application? And the answer is no. There is a Supreme Court case that explains that you don't need 5 board members. What you need is 3, at least 3. 3 is a quorum, obviously, more than 50%. So you can have a meeting and a hearing and make a decision with 3 members if you want to. Now, having said that, it is certainly your option to offer to an applicant that you will wait and continue the hearing to a meeting when you can have a full board seated. It's possible that somebody's sick and they can't be there, somebody's out of town, somebody moved away and a position was vacant and you haven't appointed someone yet to fill that. You can do that, but if you do it, it should be your policy and you should apply it evenly to every applicant every single time. So if you are offering to one applicant that you can continue the hearing and they can come back to your next meeting when there will be a full board, then you have to offer it to everybody else. You can almost guarantee that the one applicant you don't offer it to is the one who's going to challenge you on it. So don't give them something to challenge. All procedural issues like this, don't give them a reason to have something to appeal that's not related to the substance of what you're doing. It's a waste of time for everyone. Someone asks, can the board determine that the application is not complete so that the 45 days does not start to count? It's a tricky thing with zoning boards, because unlike the planning board, you don't have a statute that requires you to accept an application as complete before you start to consider it. You can have that process if you want. And if you do, like everything else, apply it evenly. And make sure that there is a paper trail and you talk about it and make that decision at a meeting. What I have seen, and I think this is a good way to go, is that the application form and the board rules say, they explain who is going to review an application and decide whether it's complete. If you have a zoning administrator, a land use administrator, something like that, if you have staff, you can use your staff for this. And they can consult with the chair and decide if take up the application at a meeting. Somebody who's reviewed it can say, I think this and this and this is missing. We don't find this, and then you take a vote. We don't find this application complete. Here's what is missing. You need to provide us with at least this much stuff before we will consider it complete and take it up. So if you document it like that, then yes, I think your 45 days doesn't start. If a planning board takes jurisdiction, but the ZBA needs more time because there are many variances needed, will it extend the planning board's time constraints? Not necessarily, no. And in that case, the planning board is probably going to work with the applicant. The applicant can always agree to extend the deadlines of things. If they say, yeah, that's great, we'll just continue it, we want that in writing. And because the deadlines are there to protect the applicant. So if they waive it, then that's fine. If the town says 10 days of notice is required, but the applicant presses to be heard and there are still 5 days for notice, is the ZBA obligated to hear the applicant, or does the town procedure or rule take precedent? In that case, I think your rule takes precedent. If you provide 10 days of notice and you tell the applicant ahead of time, here's how many days before a meeting we need you to file the application so that we can provide notice. As long as your rule is not unreasonable. If you said we need 45 days notice of a planning board hearing, I'm pretty sure a judge would say that's not reasonable. Now you're just being difficult. But 10 days instead of 5 is still pretty close, so I think that would be considered reasonable. Okay. Back to this slide. So if you don't have a full board, or if you need to substitute in alternates so that you do have a full board, or at least a quorum to continue hearing and deciding, can you substitute in somebody after the process starts? So the hearing gets opened at meeting 1, and you start going through the hearing gets continued to your next meeting. At the next meeting, somebody is absent. Can you substitute in an alternate at that point? Or say the alternate was sitting at meeting 1, and now at meeting 2, the regular member is back and they want to sit instead of the alternate. Can you do that? You can. However, you want to be careful about it. I think the most important thing is to address that in your rules of procedure. How does your board handle it? The bottom line is that anyone who is sitting on a case at the time when it gets decided is any of those people who are actually voting on it need to be fully educated about the case, whatever it is. So if a member missed 1 or more sessions of the hearing, maybe you didn't substitute anybody else in. You had 5 people at the first session, 4 people at the second session, 5 people, maybe it's continued again. And the third time is when you're going to deliberate and vote. That person who missed the one in the middle can sit, they can vote, as long as they have reviewed the record, educated themselves fully about what happened. So they'd want to read the minutes, they'd want to read any information that was, any documents that were submitted, any letters or memos or studies or whatever. Anything they missed, they need to read and catch up on. If they come back partway through and the hearing is continuing, that would be a good time for them to ask, I read this, I didn't understand it, was there more to it? As long as it is captured in the record of the proceedings somehow, that this member has educated themselves and is up to speed on everything, yeah, they can sit and they can vote. All right, so now we're up to the public hearing. Most important, the chair should be very careful about this. It should be reflected in the minutes of the meeting. The chair declares the hearing open. There's a difference between a public meeting and a public hearing. A public meeting is the board gets to talk. Other people only get to talk if the board says they do. A public hearing is a completely different thing. It requires extra notice. Certain people have a right to be heard at that point. What the law says is the board has to hear all parties, so the applicant and any abutters, and it may hear such other persons as it deems appropriate, which means people you think are going to be directly affected by whatever is being proposed. My personal opinion on that, based on what I've seen over the years, is that it's a better way to go to say, we're going to hear anybody who wants to talk, even if they live in the next town over. You might draw that line, but you don't have to. You can hear everybody. It is certainly appropriate to ask who they are, what their connection is. Are they in a butter, or where is their property located, and how are they affected? Why would this affect them? You can ask them those things. But when in doubt, it's easier to let people speak. When you are in the public hearing, board members can ask questions of the parties. In fact, board members should be asking questions of the parties. The public hearing is your chance as board members to ask anything it is you think you need to know. If you want to ask a question of a party, if the applicant has an engineer and you want to ask them things, if they have a lawyer and you want to ask them things, anything you want to know, the hearing is your shot. Because once you close the hearing, you don't get to ask any more questions of the applicants. You all talk among yourselves and you can ask each other questions, but you can't ask anybody else questions other than your lawyer, I guess. So ask every question that you have. Alternates, the law allows that alternates who are not designated to sit for an absent member to participate in the hearing process if your particular rules of procedure allow it, and to the extent that your rules allow it. So you get to define what your alternates can do. They can't vote unless they are designated to sit in place of a regular member. But many boards will allow them to sit with the board, to ask questions. Some boards will allow them to participate in deliberations and give their thoughts, but they can't vote. And that's up to you. I think it is a very good idea to encourage your alternates to attend as many meetings as possible and to give them a meaningful way to participate as they go through, because that's going to A, help train them, and your alternates are usually your best source for new members, and B, in this case, so it's going to be a lot easier for them. And it's a lot more fun for someone to be an alternate if they actually get to do something now and then. And it's pretty low stress if you're an alternate and you don't have to vote, but you get to participate. So it's a good idea all around, as long as you're clear on where the line is. They don't vote unless they're designated. What about a disqualified member? If someone has a a conflict of interest and they have recused themselves, what that means is they have, for purposes of that matter alone, they are not a member of the board. So if I am an abutter to the applicant, I cannot participate as a board member, so I have to recuse myself. Now I'm still an abutter, and I'm allowed to participate as an abutter. But when someone recuses themselves, what they need to do is get up and either leave the room if they're not a party, or they have to go sit with the public. And for purposes of that application, all they are is either a regular member of the public or a party. And that's really an important distinction, because that means that they don't get to do what board members do. They don't get to ask questions of the applicant other than the way that an abutter would. They don't get to participate in deliberations. They don't get to vote, obviously. But more importantly than that, they need to make it clear to everybody that they are not participating as a board member. They are not trying to use their status as a board member to influence the other members of the board. And I think it's the best practice for that person, if they're going to participate at all, whenever they speak, to say, I am speaking as an abutter. I am not speaking as a board member. Or I'm just speaking as a member of the public. I am not speaking as a board member. This is my personal opinion. So it's really important to do that. I have a question. What is the selectman representative's role? Officially, there is no role. Unlike the planning board, the zoning board does not have an ex officio member of the select board. So there might be a selectman who is on the ZBA, is an elected or appointed member, a regular member or an alternate. But other than that, a select board representative is really just a liaison. And the board can decide how much or how little they're going to participate. That is really up to you. In allowing everyone to speak, what is your advice when people start repeating what has already been heard and it's drawing out the hearing? It is totally fine to place limits on it, such as we don't want to hear repetitive testimony. If you are going to get up and say exactly the same thing as somebody else just said, it is sufficient for you to stand up and tell us who you are and then say, I agree with everything that Christine just said. And I echo what she said. That would be sufficient. If they keep saying the same thing over and over again, you can ask them, do you have something different to add? That would be okay. If you speak as an abutter, should you recuse yourself from the rest of the meeting? It seems odd to have a ZBA member of the body to being a member of the public. Okay. Alternate from being on the board and not on the board. The more distance you can put between yourself and the board when you have recused yourself, the better. But sometimes there really isn't any way around it. It is totally fine for a member to recuse themselves for one hearing, and then the board goes into the next hearing and they rejoin the board and they participate in that one. As long as everyone is clear about what is happening, it's okay. So the hearing can be continued to another day. If you continue a hearing to the next meeting, you don't have to provide additional notice by mail or in the newspaper or anything, as long as you state the time, date, and place of the continued session before the first session ends. So when the board votes to continue this hearing to next month's meeting, the chair should say, all right, this hearing will be continued until next month's meeting, which will be held at 6:30 in this room. You don't have to provide any more notice to people. You certainly can if you want to. Remember, more notice is fine, less notice is not. If you continue it, it's really important not to have contact between the parties and the board members in that time in between. Just like you would never go to a judge, if you are the plaintiff in a case, you would never go to the judge between hearings and say, Judge, I want to tell you all about why I'm right. The judge would say, we can't talk about this. We're going to be back in a hearing in 2 weeks, and that's when we'll talk about it. You are exactly the same in that respect. If they have procedural issues and you don't have staff, you can deal with the procedural issues, such as they want to submit documents so the board has them in time for the next meeting. That's fine. But otherwise, nothing substantive. And don't close the hearing too soon. As I said, the hearing is your shot to get all of the information you think you need. So has everybody been heard? Have you asked all of the questions you have? If you get to the end of the hearing and board members are feeling a little overwhelmed by all of the information, you might want to continue the hearing to the next meeting so that everybody can review what's happened. It can percolate in your head a little bit. And when you come back, you might realize, you might end up with some questions or some things you want to have clarified. And that way you can still talk with the applicant. You can ask them your questions and you make sure that you get everything that you need before you make a decision. Really important, as I said before, don't get rushed into making a bad decision. If you think that you need legal advice before you decide on the application, that is what you should do. You are fortunate that you don't have a deadline for the most part about when you need to decide. So if you have legal questions, if it's really complicated, if it's a variance in particular, because those can be hard to decide sometimes. If you think you need to talk with your attorney about what substantial justice means or what unnecessary hardship means, because that's like trying to nail Jello to the wall, then that's what you should do. And as Chris Bolt said, you have two options. You can have a non-meeting. A non-meeting under the right to know law doesn't exist. It never happened. No notice, no minutes, no nothing. And that is when you are talking with your legal counsel. You are getting legal advice from your attorney. You cannot deliberate during that session. You cannot make any decisions because you can only do those things in a meeting. You also can review legal advice without the attorney present And that can be done in a non-public session, a formal non-public session. You can also, and this I think is probably the most useful and what I do the most, is you can have a non-public session to talk with your attorney. Now you are in a meeting, but it's a non-public session, so the public's not allowed to be there. You can talk with your attorney. They can give you advice. You can ask them questions. What does this mean? You still can't deliberate, but that is usually the most useful way to go, so far as I can tell. Okay. Deliberating. So you've closed the hearing. And as I said, it's really important to say when the hearing is closed. The chair should say formally, I am closing the hearing. And that should show up in your minutes so that everybody can tell later when the hearing closed. After that, the only people who should talk are board members, unless your attorney is there and you want to ask them, you know, you want to run something by them or whatever. You can deliberate immediately as soon as you've closed the hearing. Sometimes that makes the most sense. You can hold all of your deliberations for all of the hearings you had that night to the end of that meeting. I work with a couple of boards that do that. It works for them. You can decide you're going to deliberate on a different day. If there's a lot of information, it's complicated and you need to take some time, or if you think you need advice from your lawyer, then you should say, we are not going to deliberate now. We're going to deliberate at another meeting. You can decide right then when you're going to do it. You can tell everybody we are going to deliberate at our next meeting, but you don't have to. And the really important point here is a deliberation occurs at a public meeting, but it is not part of the public hearing. And that means that nobody is entitled to specific notice of when you are going to deliberate. Obviously, you want to be fair, you want to be open and all of that. So it's a good idea to tell people. But the applicant and the abutters don't get mailed notice of when you are going to deliberate. They don't have the right to ask you to wait to do it until they can be present because they don't have the right to say anything. So while you could accommodate all of those requests, you don't have to. And you can only deliberate in public. You can talk with your lawyer in a non-public session or in a non-meeting, but you can only actually deliberate and make a decision in public every single time. And you want to avoid the appearance that you are not deliberating in public. And what I mean by that is there are boards that I work with where the members don't really say anything during deliberation. They say, yep, I've made up my mind. And then, you know, two people say a sentence each, and then somebody makes a motion and they vote. That is not helpful if your decision is appealed. What is helpful with deliberations, and what I very, very, very strongly encourage, is before you make a decision, review what they're asking for and review what the standards are. If there are specific criteria or factors or elements, go through them when you deliberate. If you're talking about a variance, go through all 5 factors. I cannot tell you how difficult it is to defend a decision in front of a judge when there's nothing in the minutes that explains why the board made the decision that it did. It says the written decision and, you know, the motion might say denied because there's no unnecessary hardship, but we have no idea why. You have to talk. Everybody should talk. All the board members should talk when you deliberate. But that means just the board members who are going to participate. So not anyone who has recused themselves, not from the parties, not from the public. You may not ask questions of the parties during deliberations. There are lawyers who say that there are certain limited situations where you can do it, just don't. If you decide that you really didn't get all the information you needed, what you should do is reopen the public hearing. If anyone has left the room already, decide that you were going to reopen the public hearing at your next meeting, provide notice to everybody, and then proceed from there. And again, please, 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 everyone must participate in the deliberation every single time. I'm going to look at a couple of questions here. If the public hearing has been closed and a ZBA and the deliberations begin and a ZBA member makes a motion for a decision and it is seconded, can the chair call that motion out of order if the chair feels deliberation has not been sufficient? That is an excellent question, and yes, they can. It's up to your rules of procedure. Most boards' rules don't actually do this, but I think that would be very proper. One of the roles of the chair is to try and help the board make a decision in a way that is easier for us to defend. So the chair is in the best position to say, I want to hear from everybody before we make a decision. There's nothing wrong with that. Does the ZBA need permission of the selectmen to talk to the town attorney? That depends on how it works in your town or city. So you should talk with your selectmen to see how it works where you are. Some ZBAs have a different attorney than the rest of their town. I am the attorney for several ZBAs across the state where we are not general counsel to that town. So in that case, it's up to the board. And no, I am not saying that an alternate not voting should okay. What I'm saying about alternates in deliberation is if your rules of procedure say that an alternate who is not voting can participate in deliberation but not vote, then your alternates can do that. If your rules of procedure don't say that, then they shouldn't. So it's up to your board. But the point I'm trying to get across here most strongly is the minutes of your meeting should show that the board had a meaningful deliberation about the legal standards and the facts as they found them and why they made the decision that they did. If it doesn't do that, it's hard for your lawyer to defend it if necessary. It's also hard for you to make sure that you're making the right decision. You might get expert evidence. You have a lot of discretion to choose between competing expert opinions. If there are two expert opinions, real experts, a study, whatever, you can generally choose between those, whichever one you think makes the most sense. But if you are rejecting an expert opinion, you need to explain why. There's got to be something wrong with it. The person's not qualified. They don't know anything about your area. They're a realtor in Florida, not in New Hampshire. Whatever it is, there's got to be a reason for it, and your minutes have to show why you did not, why you didn't give it as much deference. And you are allowed to use your own knowledge, but if there's an expert opinion and there's nothing contradicting it, again, you have to have a really strong reason for not going along with it. All right, motions. Follow your rules of procedure in making, seconding, discussing, and voting on motions. You do not need Robert's rules. I'm going to tell you that you probably shouldn't use Robert's rules because they're complicated. Rules of procedure should work for you. If you are fumbling through your rules, they're probably too complicated. Whatever rules work for your board, that's what you should do. Drafting a motion ahead of time. It is okay for an individual member before deliberation. The hearing closes. You're going to deliberate at the next meeting. The individual member decides, I'm going to formulate my thoughts here and come up with a motion for what I think. They're allowed to do that. They should not circulate it. There should be no discussion on it. What should happen is they bring it to the meeting with them to deliberate, and they say, I have this motion, here's what I think, I'm going to throw it out there, and then we can all talk about it. Your decision might end up being completely the opposite of that motion. That's fine. If there is a motion made to approve with specific conditions, the motion can get amended as long as you keep track. It's just like at town meeting, one motion at a time. Somebody needs to keep track. When you are drafting your motion to approve or deny, you start with what the applicant asked for. You're not required to give them exactly what they asked for. They might ask for a variance to hold 12 events a year. You might find that 10 is really all that can be held and still meet the variance criteria. You can do that. I want to explain why. You can include conditions in the motion. And this might be a place where your motions get amended over and over. There was a question a little bit earlier about can I give an example of a condition? And I totally can, which is be specific about things. So so like what I just said, you can have these events, but you can only have 12. The condition is that. Or actually, I'm going to talk about conditions in a minute, so I'm going to skip over that. So there are two kinds: conditions precedent. Those are things that the person has to complete before your approval is final and the plan can be recorded. So that is something like you need to get a DES wetlands permit, and you need to get an alteration of terrain permit, and you need to get your septic approval. And until you show us that you've done that, we're not going to sign, it's not final and you can't go ahead with your project. That's a condition precedent. A condition subsequent is something about the use of the property going forward. So if it's a variance to conduct a particular business, you can put restrictions on the hours of operation, or how many trucks per day can go down this road, or whatever it is that makes sense to you. The motion and the decision that you make needs to be really, really, really clear about what the conditions are. I want to back up to this one. Whoops, I can't back up. Okay. Well then, can I? There we go. All right, motions. The text of the motion and the person who made it and the person who seconded it, all that stuff needs to appear in the minutes of your deliberations and what happened to it. So the best way to do that is to write it down, give a copy to the person taking the minutes. You want to create a record. The conditions that you put on need to be reasonable, and they need to be related to whatever it is that you're doing. So a reasonable condition is something that won't make the project completely undoable for the most part and isn't outrageous. And conditions of approval, again, and the approval itself, it runs with the land, not the owner. So a condition that this variance will only be good until you sell your business or the property, that would be unreasonable and illegal. It would not be enforceable. A variance runs with the land. So it's not about the person who's using it. It's about the land and the use. There are a couple of exceptions on this slide, but for the most part, it runs with the land. What input do the parties involved have in setting conditions? What's a really good idea is to talk this stuff through with the applicant as you're going. Frequently it will happen that a board member will say, well, we think that you might need to do some tree planting here, or put in a buffer, or, what would you say about doing this kind of curbing along the road, the driveway where your driveway enters it, so we can prevent some runoff or whatever. And the applicant doesn't have to agree with you on those things, but it's not a bad idea to get their input, because that way, you can all work together toward where you want to end up, and talk about it. And it might be that they can explain to you why what you're suggesting actually isn't reasonable or won't do what you think it might do. Can the ZBA require approvals from other entities before they approve? No. Well, you cannot require approvals from other entities before you issue a conditional approval. So you can approve it with conditions such as you must get your DES wetlands permit. And then once you get the permit, which is like a check the box thing, do they have it? They have it, check. Then that approval is final. You can't say, we will not accept your application until you have those permits from other entities. That used to happen all the time, and the law was changed, so now you can't do it. Voting on motions, there's a question about this, so here we are. The zoning board must have at least 3 concurring votes to take any action, regardless of how many members are seated. So if you have a full board, at least 3 of you have to pass whatever the motion is. If you only have 3 people sitting, all 3 people have to pass it, even though 2 is a majority vote of the people who are sitting. But the law says the ZBA has to have 3. So you always do. If you don't get 3 votes in favor of a motion, question comes up, is that a denial of the application, or is it not a decision at all? My view is, if you don't get 3 votes in favor of the motion, and the motion could be to approve or to deny, if you don't get 3 votes, you have not taken any action. You have a failed vote. It's not automatically the opposite of whatever the motion was. So what you should do is, the motion failed. All right, let's keep deliberating. We're going to discuss. It's time for a new motion. Maybe it failed because it needs some conditions. Maybe it failed because people are not convinced of whatever the motion was. So your rules of procedure should answer that question so that you know what to do. And then you need to follow your rules. An applicant has to satisfy all 5 variance criteria to obtain a variance, and they have to get at least 3 votes. The board really needs to discuss all 5, but there's a split of opinion on how you vote on them. You can vote on each of the 5 criteria separately. There are other boards who take one up-down vote, and that's it. It's up to you which way you want to go. The law does not require you to do one or the other. What the law does require is that you have to use one voting method for all variances consistently until you take a vote at a public meeting to change your voting method, and then that change does not take effect until 60 days later, and it doesn't apply to any case that's already pending before you. And the reason for that is so that everybody has advance notice of what's going to happen. I'm going to try to go a little bit faster so I can get through the rest of this stuff. Written notice of decision. You have to issue a written notice of decision every single time because the law says you do. If you are denying an application, the written notice of decision has to explain why. There must be reasons. And the written notice of decision does a couple of things. It tells the applicant what they can do and what they can't do. It tells enforcement officials what the deal is with this property. And it will get reviewed by a judge in an appeal. What the notice of decision needs to include is the motion that was passed. If it was denied, the application was denied, you have to explain why. If there are conditions of approval, you have to state what they are clearly in the notice of decision. You should include findings of fact. You really need to include any deadlines or milestones that are required. So if somebody has to get a DES permit before they can start construction, say that in the notice of decision. Remember that you are not drafting the notice of decision just for the people in the room. It's for everybody else that might need to see it in the future. I've seen a lot of written notices of decisions that don't really say very much, and it's hard to know what they actually approved. The written decision and the meeting minutes have to be on file and available for public inspection within 5 business days after the vote. If they're not, it violates the right to know law, and it gives anybody who wants to appeal a longer amount of time to amend their appeal document. What you also have to do is make the written decision available to the applicant, whatever that means. You get to decide how you're going to do that. You can send it in the mail, you can send it by email, you can have them come pick it up. You can give them the option. You can use one method all the time. That's something that should go in your rules of procedure so everyone is treated fairly. A motion for rehearing. Anybody who wants to appeal your decision has to file a motion for rehearing with you within 30 days after the day you vote to make that decision, not the day you post it or send it to the applicant. 30 days after the vote. A motion for rehearing can be filed by the select board or city council, any party, applicant, abutters, or anyone directly affected by the decision or order. That would be somebody, usually it's a person whose property is close but not abutting, and there's a reason it would affect them. Even without a motion to rehear, the ZBA can by itself decide that it wants to rehear a case because they realize they've made a mistake. So a member at a meeting can say, I think that maybe we should rehear this case, and here is why, and the board can talk about it and decide whether they want to or not. They have to make that decision within that 30-day period. If a motion for rehearing is that the decision was unlawful or unreasonable, and the reason that the motions you get from lawyers tend to be really long and have lots of legalese is that they're teeing it up for an appeal to court if it fails, because they can't raise anything later that they don't put in the motion for rehearing. You need to grant or deny the motion within 30 days after you get it. You do that at a public meeting, not at a hearing. So it's a meeting, you have a discussion among yourselves, and you take a vote whether to rehear or not. That's it, that's all you do. Nobody gets notice, nobody else gets to talk. Just say granted or denied. If somebody gives you new evidence and says you didn't have this evidence, we really think you should have it, and this is why you should grant the motion for rehearing. If they could have presented that during the original hearing, you can consider it if you want to, but you don't have to. When you do grant a motion for rehearing, the case begins again. You schedule a hearing, you send out all the notices, everybody gets to come, they present, it starts all over again from the beginning. It's not limited to the issues that were in the motion for rehearing. You basically just start all over again. And then a few things about appeals. Appeals to Superior Court. If a motion for rehearing is denied, any person aggrieved, which is basically anybody who could have filed a motion for rehearing, can file a petition for appeal with the Superior Court or the Housing Appeals Board within 30 days after the board's vote to deny rehearing. And at that point, you are going to need to compile the record. The certified record is what we submit to the court. It includes everything you've got on this case. So the application, all the correspondence with the applicants and the abutters, documents, photos, all of the evidence that was submitted, the written decision, your notices, your certified mail receipts, everything. The court is going to set a date by which you have to submit that. It's usually 30 days after the town is served with the appeal. And you should work with your lawyer to assemble that and put it together. There are certain things that generally don't go in there, but you should assume that everything goes in and then let your lawyer weed out what doesn't belong there. And I want to make one more comment on certified record. That is the evidence that the judge is going to have. So part of the reason that I keep harping on put everything in the minutes and everyone should talk and we need to know why you did what you did is that when your decision gets appealed to the Superior Court or the Housing Appeals Board, you are probably not going to go and testify in front of the judge. The judge is going to look at the certified record and the lawyers are going to argue about what it means. And that's it. So if it's not in there, we can't use it for the most part. That's why it's so important. All right, I'm going to answer some questions in the few minutes that I have left. Let's see. I'm going to zip back here. Okay. Can a board request their staff to draft a list of possible motions for the board and have the staff submit it to the entire board? Absolutely, yes. And many boards do this. Boards that are fortunate enough to have professional staff do that a lot. It's really useful. And the great thing about that is that staff can contact your attorney and they can kind of work back and forth together to make sure is that staff will draft motions that go both ways. So they're not telling the board what to do. They're saying, here are some ways to think about it. And we're going to organize the information for you. And then it's up to you as the board members to decide what you want to do with that. It's a great suggestion. Does DES overrule the town spirit of the ordinance? No, they are separate. So DES can approve something that does not work for you. Just because DES approved it does not mean that you have to. And it goes the other way too. Just because you approve something doesn't mean that DES has to. They're separate. And applicants will frequently say, well, DES approved it. There are certain things where DES does control. If your ordinance says that an applicant for a certain project needs to have DES septic approval, if they get DES septic approval, then they have it. So that issue is closed. But it's very specific. It's only if your ordinance actually says that. On voting for each separate criteria for variances, if a ZBA member who votes no on any of them, should they then vote no on the final decision? Yeah, that's a really good question, because what can happen is you have 5 members, you have 5 criteria. If every member votes no on a different one, then each one had 4 members in favor and 1 member not. But no criteria, there's at least every board member thinks that they failed on at least one. So that's sometimes why the 1 up-down vote is better. If you're just going to take 1 up-down vote, what is extremely important is to have a vigorous deliberation where you talk about all 5, and then the motion to deny would say denied because this criterion was not satisfied, and here's kind of why. And if you can't agree on that, keep talking. There's no limit on how long you have to deliberate. just keep going until you get there. Whoops. For conditions, do the specific actions the applicants say they will do in the application need to be made a condition of approval? Well, I think there's a balance in there. If there may be some that you feel like you need to call out. If it's not part of the actual application, if it's something extra they said during the hearing, and it's maybe, you know, like a supplement that they proposed, or just something that they said during the hearing, if it's not in the application, or if you want them to do something different than what's in the application, it really needs to be stated clearly as a condition. If it's in the application very clearly, you can say this application is approved as applied for. Or, you know, if it's some of each, you can say as applied for, except these things. But if it's really important to you, I think you should call it out as a condition, because it can be very difficult later to prove that something was part of the approval if you don't say it. If a prior ZBA gave a variance for a specific use and an applicant is using that prior variance to do something different, what options does the town have? Well, that's an enforcement problem. If a person is not complying with the variance, if the variance was for a specific kind of business and your ordinance doesn't say you can change from any, you know, I mean, usually if it's for a specific business, that's all they can do. They want to change it, or they want to add something, they have to come back to you. But that's an enforcement problem, not a ZBA approval problem. How can you work with them on conditions if the public hearing is over? If you're in a deliberation phase, you're only in a public meeting. Yes, that is true. And so when I said talking with the applicant, it's something that you would want to work with them during the hearing process if it comes up. And frequently it will. You'll think, well, you know, this might be okay, but maybe we need to put some limits on this. And if that happens, that's fine. You talk about it with the applicant as much as you can during the hearing process. Once the hearing is over, you're right, you can't talk with them about it anymore. And can I unmute them? Oops, nope, they left. Okay.
They left. Okay. Yeah, I can unmute them, but it looks like they put their hand down.
Okay. All right. Well, I tried. Let's see, a couple more. Can a board's bylaws serve as the rules of procedure, or do zoning boards need to have both? There's nothing special about the terms bylaws and rules of procedure. They're really interchangeable. Call them whatever you want and follow them. They're sort of the same thing. You might want to have, you know, different sections of your rules that deal with different things, but they're really all the same thing. If a motion to approve an application fails, then do we need a motion to deny the application? Yeah, I think so. You need a new motion of some kind. You could say, if the motion to approve failed because people think it needs some conditions put on it, then maybe you talk about that, and the next motion that's made is to approve with these conditions, and maybe that passes. Or maybe the next motion should be to deny, and here's why. So whatever seems like it makes the most sense. The most important thing is there should be another motion at some point. Some kind of motion has to pass, whatever it is. Can the video of the hearing be submitted as part of the certified record? No, it does not. Well, it doesn't substitute for the certified record. And in the first instance, we don't include it. I have frequently seen where the party who's appealing wants to include the video of the hearings. If it exists, you don't have to have it, obviously. And sometimes we agree and sometimes we don't. Usually that will require a motion to the judge or the Housing Appeals Board to expand the record, and they'll explain why they want to include it. It's more expensive now than it used to be because now we have to provide a transcript as well. So that means that if it does get included, we have to have somebody create a transcript that we also submit so the judge doesn't have to watch it. And sometimes that's worth it. Sometimes we do want the judge to watch it because the person is arguing that a board member was biased and their body language indicated something. And I can think of a specific case where that board member's face, you couldn't see at all on the video. So it actually worked in our favor to submit it, but it's not automatically part of it. Can the ZBA interview someone interested in becoming an alternate? Sure. Can the ZBA recommend a person to the select board to be appointed to the ZBA? Sure. The rules are a little different depending on if you're elected or appointed. So you'd want to check with your lawyer on that. But if you have thoughts about someone who might become a member of your board, and if you are an appointed board, so you don't appoint your own alternates or fill your own vacancies, you can give your input for sure. And so concluding suggestions, everybody on your board, new members, old members, everybody, and your staff should take some time to learn about the laws and the ordinances and the rules that apply. Coming to workshops like these are useful. Somebody just said it's like drinking from a fire hose, and that's totally true. So I think there's always something new to learn. OPD has a lot of great resources that you can use. Stay up to date on changes in the law. There have not been a lot in the last year, so that's been useful. But your procedures might not be current. And as I said, you have to do things the way the law says you have to do them. So if something changes and your rules haven't kept up with it, you might find yourself in trouble. Stay in touch with your enforcement officials and your planning board, because that might help you do a better job at crafting your notices of decision. If there's a deadline or a milestone or something that the applicant has to meet, you want to put that someplace where your enforcement officials can find it, because they're the ones who need to keep track, and then let them know about it. Send them a copy. If you and the planning board are at odds a lot, it might indicate that there's something wrong with your ordinance that needs to be changed. So very, very frequently I will see a zoning board say, we are getting a ton of variance applications for exactly the same thing in this neighborhood. We think the setback is just unreasonable. That's something you can bring to your planning board. It's up to the planning board to decide whether they want to propose that as a change, but that's useful information for them to have. So stay in touch, and then see how other boards in your municipality and those in other municipalities, someday when we're all back in the same room and you all can talk to each other, that is one of the best ways for you to find out how other people do things. And you might see that they do something in a way that could work for you. Oh, and one last thing, Noah, I realize we're out of time, is that recently I have started suggesting that rules of procedure for land use boards include the option for the chair to have someone else on the board run hearings now and then. Because I keep hearing that the chair is the only one who knows how to run a hearing and how to run a meeting. The best way to learn, aside from watching it and sitting through it, is to do it. So if your rules of procedure say the chair can designate another sitting board member to run a hearing, they can do that. And you might choose a really low stakes one that's really easy, non-controversial, not a big deal. And that way the chair is sitting there and they're available to step in if something goes sideways or if the procedure gets all messed up. And that way you have more than one person who knows what they're doing, so that if the chair suddenly can't do it, either because they can't be there or they're disqualified, which could happen, now you've got somebody else who can do it. So just a suggestion. And with that, I am out of time. If you have questions you didn't think of, or if there's something I didn't get to, please do feel free to send me an email. My email address is here. And just please remember to say on the email that you were attending this session so that I have some context for why you're asking. Thanks. Thank you for having me.
Well, thank you so much, Christine, for another great session, and thank you to everyone for attending and for all the great questions. As Christine said, if we didn't get to your question, feel free to email her. And OPD would also be happy to answer any questions you may have as well. As I mentioned at the conclusion of the last session, the slides of the webinar are already on the conference webpage.